Hello everyone. Thank you for joining us at this Your Overseas Home webinar. My name is Christopher Nye and I'll be hosting this session. Sorry, police car going past well, we are doing legal matters. I'll be hosting this session. Today we will be discussing Spanish mortgage claims. It's great to have you all with us today, whether you're here with us live or catching up on demand. We're delighted to be able to help you realise your dream to own a property overseas, and to help clear up any matters from when you've owned before, as in this case. Today's session will be a maximum of 30 minutes, and for those of you listening in live, there'll be plenty of opportunity to put your questions to Emma Belgam and Javier Valiente from JLCA. If you do wish to ask anything, please type your query into the questions tab on the right-hand side of your screen. If you need a reminder of anything discussed today or want to share this with family or friends or anyone you hear who has a similar problem, has had a similar problem, it will be available on Your Overseas Home website to watch at your leisure. So I am joined today by Emma and Javier from JLCA, and Emma and Javier are going to do a little sort of introduction of themselves and just sort of lay out the basic issues that we're talking about, and then we will answer your questions. So over to Emma and Javier.
Wonderful. Thank you very much, Chris, for the introduction, and good afternoon, everyone. Thank you for joining us today. I'm Javier, and I'm the manager of our UK office for JLCA Lawyers. We are a Spanish law firm, and we're dealing with Spanish matters, although we do have a representative office in the UK. And I'm joined today by my colleague Emma, who is in our Spanish office, where we're headquartered in Alicante. And the subject matter for today, it's mortgage claims, and it's something which we feel anybody who's taken out a mortgage from 2004 onwards must have been, more than likely has been affected. Hence, it's quite topical at the moment, and we'd like to inform you as to who can make a claim, why you can make a claim, and the legal basis behind it. A mortgage claim in Spain, this particular mortgage claim refers to what we call in Spain floor clauses. It's otherwise known in the UK as a collared mortgage, which some of you may have heard about before. This is a clause that was introduced on all mortgage contracts for 90% of the banks from 2004 through to about 2009, 2010. And to explain what a floor clause is, or a collared mortgage is, it's literally a collar on the rate that you'll ever pay. So typically, a mortgage is in Spain, they're variable and they track Euribor. What a collar adds to your rate is to say that your mortgage will never be less than a certain percentage. So, for example, if you have a collar of 3.5% above the Euribor rate, which is equivalent to the LIBOR here in the UK, then it means that regardless of where the Euribor goes, you'll never pay less than 3.5%. So this was introduced into mortgage contracts in Spain, but it was introduced not as a product, rather as a hidden clause. And I say hidden because if you think of a mortgage contract, which is about 38 pages, it was stuck in page 34 in very small print at the bottom of the page. This is different to taking out a collar mortgage, where that's an actual product. So when you take out a mortgage, you're given the options of taking a variable rate, a fixed rate, a tracker. There's all sorts of mortgages out there. One of them was a collared mortgage. So you entered into a mortgage contract knowing exactly that you were entering into a collared mortgage, which may have other benefits such a cap as well. So you played with that. In Spain, however, you were just taking out a mortgage, and this clause was inserted whether you liked it or not. Now, when rates were fairly substantial, when Euribor, it's from 2004 through to about 2009, when we had the financial crunch, when Euribor was in the fives and sixes, this clause went largely unnoticed. The collar was at 4%. So if you were already paying 6% plus a rate on top of that, then nobody really noticed. Nobody even knew of its existence. However, come the financial crunch in 2009, and Euribor, just like the Bank of England base rate, started dropping to pretty much floored at zero. Um, and this is where the clause became apparent, because rates were going down, yet people's mortgage rates, mortgage payments weren't going down. It caused alarm. This clause came to light, and it was taken to court. A set of lawyers took it to court, and they won it. Supreme Court eventually deemed it as an abusive clause. In other words, it wasn't explained at the point of sale of a mortgage contract, and it wasn't made aware properly that this was in existence. It was declared abusive, and the Supreme Court said that contracts such as that that clause must be declared null and void. Now, having something declared null and void means it never existed in the first place, meaning you have to be reinstated as you were had it not existed. Hence, a claim can be for all the extra payments made up and above the collared rate. So if someone had a mortgage of 1% it was about the average, it's about 1% above Euribor, Euribor dropped down to zero, and you should have been paying just 0 plus 1%, yet you were collared at 4%. That difference of 3 over a period of 6, 7, 8, 9 years must be refunded to you, along with interest, legal costs, etc. So these can be fairly substantial claims to anyone affected by them. Furthermore, of course, the banks didn't just relinquish that easily. They took this to the European Court of Justice. That was back in 2014, 2015. I don't know the exact dates. And one of the lawyers in our firm was actually involved in that tribunal at the European Court of Justice. It was won, and the European Court of Justice, so there's no further appeals that can be had, declared it also abusive, hence opening the doors for anybody to make a claim. Now, to put into perspective, if we were to look at a claim, or rather, let's say someone taking out a mortgage in 2006 for £150,000, and he had that mortgage for 9 years, all the way through to about 2013. This clause would have affected that person from about 2009 onwards, when Euribor started dropping below the 4%. That person, if we calculate the amount of interest over and above what they should have been paying, had that clause not be there, from about 2019 to about 2013, 2014, based on a 150,000 mortgage, and if we had legal interest and legal costs to it, we're looking at a claim of circa 20,000 euros. So these are fairly good claims. They're not to be snubbed at. They are processed fairly quickly as well. And the reason I say that is because, given the flood of claims that came through on the back of this, special courts were set up in order to deal with them. A bit like sort of PPI. It was a mass claim market, and everybody's doing them. Who's eligible to make a claim? It's pretty much anyone who held a mortgage during the affected period and had that clause. And as I said, 90% of banks inserted that clause. So I would say about 90% of mortgages were held. So if anyone who's held a mortgage during the period of 2009 to about 2016, by 2016, banks removed that clause. Will potentially have a mortgage. So it could be a mortgage that you've had in the past. You do not need to have it anymore. It doesn't matter whether we've even had people who've been repossessed properties and actually were in breach of contract. Doesn't matter either. This is a contract to declare something null and void. There's no limitations to it. There's no time limitation either. There's no statute. I mean, we do have statute of limitations on claims in Spain, but when it's something declared null and void, that's got no statute of limitations. So you can go back as far as you can, and you can claim today as you can in a year's time as well. Emma, could I ask you perhaps to A, introduce yourself, and B, perhaps go through what documents will be required and what the process is like of running one of these claims through our office in Spain?
Okay, thank you. As Javier mentioned, my name's Emma Belgum. I'm based in the main Alicante office. In terms of the documentation and process, as Javier has explained, the gravity of these claims means that it's well worth you having a look if you do have a possible claim, even if you're not sure, because the basis of this is that we can have a look and check for you, and that is without charge and with no obligation. So it doesn't cost you anything just to have a look. The most important document that we need to see in order to verify if you have a possible claim is a copy of the actual mortgage deed. So that is the primary document that we're looking for, and also information with regards to the payments. Now, ideally, amortization table of all the payments made, but more realistically, mortgage statements over the years or receipts will give us an idea of how much you've paid and when, which then allows us to calculate what possibilities that you've got. But as I say, number one document is the mortgage deed. That's what we need to see, because in that we can firstly check, do you have the clause, and then work out what period of information that we need in order to calculate what the options are for you. Now, many people will already have a copy of that deed. They would have received one at the time of signing the mortgage. If for some reason you don't have that anymore, you've got several different options of how you can get hold of it. Now, first of all, many of you will have used your own lawyers when you were purchasing the property. So that could be your first port of call, just to contact them and see if they've got a copy. And of course, you can directly contact the bank with the mortgage that you've had. It's information that they hold for you, and there shouldn't be any problem for them to give you that information. That being said, if there are any problems in getting documentation, it is possible to authorize us to do it for you on your behalf. We would just need to have sufficient authorization, and by that, realistically, we mean a power of attorney, because that is seen as the strongest authorization you can have here in Spain when we're requesting this kind of documentation, bearing in mind the gravity of the information that's held. They want a strong authorization. Now, these powers of attorney we can help arrange with you. They don't need to be signed in Spain. There are many notaries in the UK that we deal with on a regular basis, so we can help arrange that. And then once we've got that document, then we can actually contact these entities on your behalf to get the information. And the whole idea of this is to get everything together to find out exactly what your options are, if there is a claim, and how to go forward with that should you wish to do so. Now, the actual process itself, should you then decide, yes, I am going to go ahead and we've got everything in place, we start off with submitting an extrajudicial claim against the bank. This is a normal process, and the majority of the time they do not comply with that extrajudicial claim. The reason being is that they don't want to be making payments where they don't have to, and once they've actually been forced by a court, they have no choice. So they tend to leave it until they've got been pushed as far as they can before they actually make the payment, which means we start the judicial claim against them. And as Javier has been explaining, this is something that, because it's based on such strong legislation, this means that we're able to push through the courts in what we would call quite a reasonable period of time. Within a year and a half, typically, you can see processing getting through to judgments, depending on courts. So that is the basis of it. We do say, if you've got even an inkling that is a possibility, do send it across to us. We can confirm for you. Majority of the banks had stopped in 2013, 2014, but there are some that went on a little bit longer than that. So we can check and see if it's there for you. I mean, that's the basis of everything. I don't know if Chris, then you'd like to ask any specific questions.
Yeah, I have some yes, I have some questions. Well, firstly, I was just going to say, I well remember when I got my one claim I made, a PPI or something, and I just remember getting this check for £10,000 through the post, and it wasn't money I expected. It just arrived, and it was one of those great days. So it's definitely worth making that claim if you can do. So we have a few questions. One is from Elaine. She says, my mortgage was taken out around October 2003. Is it applicable? Do you think there was some clause like that because my payments did not go down at a certain point?
It's very probable. Yeah, very probable. Because I mean, these clauses became mainstream by 2004, but they started being inserted as early as 2001, 2002.
Right.
So it is very possible.
Okay, and her bank, I imagine that she said Cajamar. Is that a bank?
Cajamarca used to be, yeah. I think it's probably
Okay.
now been absorbed by Popular or one of the larger ones.
Okay, well, that's an interesting question then. If the bank has been absorbed, is that a problem?
No, none whatsoever. We just had to go back to the bank that that took it over. The liabilities go with it, and as far as I know, no single bank, Emma, you'll know better. No single bank went insolvent throughout the crisis. Every single one got absorbed by the Bank of Spain or by the larger banks. Is that right?
No, absolutely. I mean, some of them have gone through 3 or 4 mergers in
Yeah.
a very, very short period of time, but it's still just a case, get the documentation that was originally there and trace which bank that is, and then we would go against that current bank because they absorbed the responsibility as well as all the other information they did for the clients.
Okay. Now, here's a question. I'm still paying the mortgage. Can I make a claim? And if so, what does that mean for the rest of my mortgage?
Nothing. I mean, all that will be declared null and void is that clause that was inserted. So it won't affect any other terms of your mortgage. The basis of the claim is to remove. It's not rude because if you remove it, it just takes away liability from this point onwards. Declaring that clause null and void as excluded for means it never existed. You have to be reinstated as it hadn't existed. So all we do, you can carry on your mortgage as it is now. If you're still affected by that clause, should have been removed by now. I'd be very surprised if it hasn't. But you would have been affected by it at some point throughout your contract. So if it's still there, it will be removed. If it's not there anymore, we'll work out during what period it was still there, work out the overpayments made, and claim accordingly.
Okay.
But it won't affect the rest of the terms of the mortgage. It can just continue as normal.
Lovely. Okay. Now you mentioned this already, but you say if I have foreclosed on the mortgage, the property was repossessed.
Mm.
I can still make a claim.
You can,
Yes.
yeah, absolutely, yeah.
But if it was repossessed because they were artificially charging me too much money, do I have any other claim? I mean, is it just what about the cost of the repossession?
I mean, if we can argue that it was repossessed due to an affordability, and that affordability was due to an unfair rate, then um, I mean, if on repossession a bill was sent to somebody to pay the outstanding balance and it was paid, we can certainly recover that. If
Okay.
a property was repossessed and there was an outstanding balance which was never paid, what this claim would do was reduce that balance.
Sure. Okay. Now, here's a question. I sold my property, paying off the mortgage in the process. Can I still claim? I imagine this would apply to most that they now don't have the property. So hopefully one can still make a claim.
So can you repeat the question again? Beg your pardon,
Yes.
please.
The question was, I sold my property, paying off the mortgage in the process. Can I still make a claim?
Absolutely. Yep. As long as you were affected by that clause. Yep. So essentially what that means is that you haven't got the mortgage anymore. You paid off the mortgage, whether through the sale of the property or because the mortgage come to an end. Regardless of whatever reason the mortgage was ended, including a repossession, as we discussed, if you were affected by that clause, we take the years upon which you were affected by it and make a claim accordingly.
Okay. Now this person bought 3 apartments to invest and then rent them out. Does that make any difference?
Yes, it does. Actually, yes, no, it doesn't actually. No. So I was thinking about another type of claim where if it's for commercial venture, you can't make a claim. But in this instance, yes, you can make a claim even if it's if it was for commercial basis, because it's an abusive clause.
Okay. Okay. And this next person, I bought my property in the name of a company. Does that change anything?
Same reasons, no. As long as a company is still in existence, because the claimant would be the company.
Okay.
So,
Okay. That's good. Can I ask? So it's a no-win, no-fee arrangement. So if you take it on and you can't win anything for me, I've not lost anything. But how much a percentage would you take as your fee if we do win?
Okay, so yeah, that's quite right. We will take claims on a no-win, no-fee. So we will not charge any fees up front for our service. We will even cover disbursements apart from notary fees, which are in the region of Emma mentioned you have to get a power of attorney done. That's got to be notarized. The fee for notarizing it is maybe 150 to 250 pounds. So besides that, we will take the whole claim on a with no fee, and we will charge a 30% fee on any awards received. So we would have to A, win the case, and B, recover an award before our fee would become chargeable.
Brilliant. Okay, so I would keep 70% of something that I didn't know I was going to get. So that's not a bad deal.
And with no risk involved.
Yeah. And with no risk. Yes, exactly. Okay. So let's assume that I want to do it. I have a claim. I start today. When if everything goes in a normal way, when might I receive my check?
Over to you, Emma.
We would generally assume with claims across the board, we normally say from presentation of claim to receipt of a judgment is a year to 18 months, depending on the court and depending on the bank. So it can be a little earlier, but typically around about that time. And payment with these claims, I mean, the important thing is that we're claiming against banks, which are solvent entities, which makes the claiming the money easier. So normally, if they didn't pay voluntarily, which some do straight away, and enforcement typically takes 4 months after that, 4 to 6 months.
Okay. Now I know that in some with some claims, if you can prove that you got some sort of hardship, then things progress quicker. Is that the case with this one? So if I'm unemployed, say, is the bank duty bound to deal with my claim more quickly?
No, this it is purely based on the claim, the documents and submission, and they are dealt with in order and pushed through that way. And then, of course, depending on how quickly the bank pays after that, but there isn't any way of speeding it up other than the constant pushing that obviously we do to try and get it as quickly as possible for our clients.
And there's no sense in which there might be an idea of, well, British people, they're not in Spain. You know, will it be any slower for us?
No, again, everything is treated equally within the courts when they're going through. And even if you are British, do remember that you've got a very good team of Spanish lawyers that are actually pushing forward for you. So no, there's no difference whatsoever on nationality.
I was going to say that's one of the advantages, of course, of having a firm of lawyers over there. Okay, let's just sort of open it out a bit. Are there any other kind of claims that you deal with for former property owners in Spain?
Yeah, I mean, our firm has a heavy accent on real estate matters, dispute resolution, litigation. So there are, unfortunately, not many, but some people can have problems with a property they bought in Spain. I'm talking about construction defects, snagging issues, developers not delivering on time. So one area which we've been specializing a lot recently, and again, these claims, because we're so sure that we're able to take on a no-win, no-fee, are claims against developers for snagging, construction defects, or any nuisance that a brand new property is not sold as described on the sales sheet. People might not be aware of this, but we have exactly the same protection laws in Spain as we do in UK in terms of a 2-year period for any kind of snag on the property from point of buying it, all the way through to a 10-year period for any construction defects, such as the equivalent of an NHBC certificate in the UK. So
Okay.
so we quite often do get contacted by clients who we've helped purchase a property. I'm talking about sort of property new developments, new properties, which normally what people buy in Spain. And they're going through a lot of issues with it, and we've helped them fix it either by forcing the developer to get on with it and not just delay and ignore requests for repairs, either expediting that matter, or if not, taking them to court and claiming not just obviously for defects, but also for moral damage and any other undue stress that it may have caused.
Okay. Now, for people who are who have been through it once and are now looking to buy a property again, well, firstly, does your law firm deal in property buying?
No, absolutely. We work quite extensively in the purchase process. Part of the work we do is to make sure when somebody is buying a property that we do all of the checks beforehand to make sure that the client is fully protected, to try and avoid these problems that could happen, so that you've got peace of mind right from the start, and build in within the contracts clauses so that if things aren't as they should be, that you're able to come out with your money and then put that money into another property, so that you will eventually end up with exactly what you want for the price you're expecting to pay. So we are very happy to talk to people very early on in their stages when they're talking about buying property, because we can have a look at all of the different areas and thoughts that they might have and offer advice before they start coming out and having a look at property, so that they've got a much clearer picture of what to expect, what they're going to be asked, what they should be negotiating and thinking about, so that they just feel more confident from day one that they know exactly what they're doing.
Okay, brilliant. And to finish off, I suppose the message is that you know, back in the day when these kind of clauses came in 2003, that was pretty much when I started in the overseas property field, and it was a kind of wild west in those days, wasn't it? But people can be confident now that it's much safer. They can buy with confidence.
Absolutely. I mean, in the past, there was a reputation of these sort of problems, but there's so much regulation in place, and if you've got a good independent lawyer that's working with you, then you can always have peace of mind that anything is being checked for you and you're being covered at all times.
Brilliant. Okay, well, I think it's probably time to wrap up there. Can I thank you, firstly, Emma and Javier, for all your insightful tips and advice. And we do recommend that viewers get in touch with JLCA directly. You've got the details all there. The phone number's there. It's a UK number, so you don't even have to stump up for an international call, or visit the website and to discuss your requirements or your worries or your concerns or your potential claim with Emma and Javier. Thank you to all our viewers for watching this session. We wish you all the best in your move overseas. We do have lots of resources available on the site, all about buying, all about immigration, all those visas, all those residency issues too. So do take a look at the webinar recordings and guides. And one last thing before you all leave, I would like to announce that we have a big virtual event coming up on the 12th of November. Seems ages away, but it's only about 6 weeks. This will be an online all-day event where you can access all the information and speak to experts like Emma and Javier in person, just like this, in a one-to-one setting. So thank you again, Emma and Javier. Thanks again for watching, and happy property hunting. Bye-bye.
Thank you very much, Chris. Thank you, everyone.
Thanks, Chris.
Cheers. Bye.
Bye now.